Hello, welcome gentlemen. I am your speaker for case study of Krishna Water Dispute I. Prior to 19th century, the development of Krishna water in all the riparian states and princely states at that time was just small tanks. The large scale development started in the middle of 19th century from from 1855. Actually, is rising near Maharashtra in Western Ghats. The river travels from Maharashtra right up to Bay of Bengal through different states. At that time, in the 19th century, there were Bombay Presidency, Madras Presidency, states, Hyderabad state, that is the Nizam, and so on. After the major irrigation development in Krishna Basin has started, and the first Krishna Delta development, which was started Vijayawada Anicut and the Delta area. Similarly, the development has started in Bombay state on Nira system,
इसको बंद कर ना बात राजा इसमें इसको वॉइस कहाँ है
Ashok, you are
Sorry, friends. Due to some teething, I was offline for some time. So we were talking about how the major irrigation works started in 1855. That is the first development was Krishna Delta. Kundur-Kadapa Canal, commonly known as KC Canal. In the Bombay Presidency, India Canal's development was started. Similarly, Mukha Canal development was started. And Bhavani Vilas Sagar construction was taken up. On the Huddar development part, Tatas have planned by diverting water from Krishna Basin across the Konkan area for development of Huddar potential. And all these works were going on from 1855 to 1930. At that time, because the availability of water compared to the requirement of these projects was ample, there was no scope for disputes. Post 1930, the then government Government of India Act 1935 by which water became an exclusive provincial subject and special provision for settlement of water disputes was made. Provinces of Maharashtra, State of Hyderabad, Mysore, other princely states had riparian rights in the Krishna basin. Prior to 1935, there were couple sharing of the Tungabhadra waters. Those were in 1893 and 1933. In 1944, during July, another supplementary agreement was made for sharing of Tungabhadra waters. And this agreement enabled to undertake construction of Tungabhadra project, Rajori Bandha diversion scheme project, Tunga Anicut, providing irrigation facilities to the Madras province Mysore, and state of Hyderabad. After independence, Government of India has applied Constitution in 1950. All the principal states, most of them, were merged as one India, and therefore there of Bombay, Mysore, Hyderabad, and Bombay and Madras dependent on the Krishna basin water. Intensive development of water resources was planned by the for utilization of Krishna waters, and the major projects like Koyna, Upper Krishna, Lower Krishna, Krishna, etc. were being taken up in hand. While these projects were in planning stage, there was a need for agreement for sharing of the waters. So in 1951, the central government invited all the 4 states a meeting at Delhi for 2 days on 27th July and 28th July 1951. The then Central Water and Power Commission a note of what is the probable availability, how the waters can be shared, and extensive arguments, counter arguments in this meeting were held. Some understanding was developed between the parties for sharing of the waters. However, state of Mysore has not ratified that agreement and was of the opinion that the matter should be further taken up at a later date. Meanwhile, as per the constitutional provisions, the Planning Commission continued to clear the projects under the assumption that the memorandum drawn in 1951 is a sort of agreement between the states and it is binding on the states. In 1953, the government of India brought the Andhra State Act, which is called Andhra State 1953. Similarly, in 1956, the State Reorganization Act was passed, by which, on linguistic basis, the states were created. As a result, the state of Bombay, Mysore, and Andhra Pradesh were the only three which became the part and parcel of the Krishna Basin. Due to these territorial changes, the Central Water and Power Commission further drew up a scheme for reallocation of Krishna water. However, this scheme was not accepted by states. Meanwhile, in 1956, when the reorganization was placed, the government of India enacted under constitutional provision, Article 262, an Interstate River Act 1956. As Act, water dispute regarding use, distribution, or control of water, and courts, including Supreme Court, have jurisdiction over water disputes. I think in earlier lectures, this part has been adequately dealt with. However, I will mention a couple of provisions of this Act. So as per this Act, Section 3, the parties, when they feel that the dispute has arisen, they have to refer the matter to the central government by drawing their letter of complaint. Such letter of complaint may be by one state, or maybe all the states, or maybe by a couple of states of the basin. And when it reaches the central government takes initiative to resolve this matter by negotiations. And attempts are being made. All party states come together, have some understanding to resolve the dispute. So in such cases, cooperation between the party states and mutual understanding is very important. But it all depends on the wisdom of the people's representative, and if possible, the agreements are drawn. And classic example of this is resolution of Godavari water dispute. However, in Krishna water dispute, such negotiations could not materialize, and therefore consider the provision of Section 4 the central government constituted the tribunal. The small mechanism which is there is illustrated in this slide, in which under section 3, as already I told you, complaint by nation state to central government, followed by efforts to resolve the disputes through negotiations, and if the negotiations fell under section 4 provisions, the central government appoints the tribunal with the help of Supreme Court. The central government is the Supreme Court for appointment of a chairman, and Supreme Court suggests the names of 3 persons, one sitting judge from Supreme Court and 2 the sitting judges from the high courts. What is being watched? None of the 3 judges have any interest in the party states. That means they are out of cohesive states. Once the tribunal is constituted, the tribunal initially holds a meeting of all the concerned people. The state governments to present their case before the tribunal appoints distinguished counsels. They may be advocate generals of the states or some other counsels who are well acquainted with the water disputes acts, sharing of water principles, and to assist these counsels, team of experts comprising of officers from the state government as well as or experts for deposing the case before tribunal are appointed, and names of these persons are communicated to the tribunal. The tribunal then directs the states to submit their statement of case or statement of claims, and these documents are to be exchanged between the party states. Having received the statement of case, the party states, with the help of their counsels, their experts, go through the documents and then give them rejoinders. These rejoinders are again studied by the different party states, and replies, counter replies, they go on, and finally they say now our pleadings, written documents are complete. While these exchanges are going on, all these matters, with the help of councils of the party states, the next step is to frame issues are framed by the tribunal. Then tribunal directs the party states to submit their witnesses through examination in chief, that is the affidavits. Whatever their studies are there, whatever they want to say, all that things are to be submitted. For this exchange, then submission of, then deposing by the witnesses, then their cross-examination, thereafter arguments by that party states, counter arguments by other states. The process continues, and as per the Act, it is expected that this should be completed in 3 years period since the constitution of the tribunal. Usually, it takes a lot of time. So, a provision has been made for extension maximum to. So, within these 5 years period, tribunal is expected to complete the hearing, their award. That is the provision. If this is not completed in that, then to go to the parliament. So usually it takes 5 years to complete, but in meanwhile some certain circumstances may develop and extensions are required. They are usually granted. But the proceedings are normally completed within 5 years, and an award under section 5 is declared. Once this award has been declared, it goes to everybody, including central government and party states. Everybody studies what has been stated therein, and if any clarifications are required, then the clarifications are sought by 5.3 provision by the central government as well as the basin states. Again, arguments continue, but this time there are no witnesses and other. And after careful considering the arguments of the party states and central government, the tribunal gives its decision under section 5.3. This decision is a final decision. This decision given by the tribunal, notified in official gazette, it becomes a binding award of the party states, and central government accordingly acts as per the directives given. So this is in nutshell the procedure, how tribunals function, how award is given, and final notification. On final notification, the award is binding. Meanwhile, in 1960, after the reorganization of the states, another interstate conference was held on 26th and 27th September 1960 for finding out some settlement. In this conference, the existence and validity of the 1951 agreement was challenged by the party states. The party states also raised objections to clearance granted for new projects on the 1951, which according to party states is not a valid agreement. State of Mysore, which is now state of Karnataka, has not accepted this as an agreement. In 1951 to 1960, major constructions were taken up for Nagarjun Sagar, Musi Dam, the Tungabhadra High Level Canal Stage 1, Koyna Hydel Stage 1, Khavatwasla Stage 1, which is the Mutha Canal system, Ghataprabha Stage 2, Koda Dam, Veer Dams, for Neela system, and schemes were put forward by the state. But major objections were on Nagarjun Sagar, Sri Shailam by the party states. Achha. So, consider the provisions of the 1956 Interstate Water Dispute Act. The first who made reference in January 1960. In May 1961, government appointed Krishna Water Commission conditions, water availability, and all those things. And this Godavari Commission submitted their Commission report is that without further data, difficult to find dependable flow and both rivers. Therefore, inadequate to meet of projects. They indicated some programs that could be adopted with respect and new projects. That Godavari waters can be diverted to Krishna Basin, and they suggested systematic river gauging to be carried out at key sites on both Krishna and Godavari rivers, followed by reference of January 1962 by the state of Mysore. The state of Maharashtra in June 1963 requested for reference. Meanwhile, on 23rd of March 1963, precisely, Union Minister for Irrigation and Power stated that the agreement of given is void according to legal opinion. If it was not initially void, at least partially it is void. No new projects should final allocation, but withdrawal of supplies of Maharashtra, Mysore and Andhra Pradesh should be limited to 400 TMC, 600 TMC and 800 TMC respectively. TMC is 1000 million cubic feet. So with these provisions in mind, the clearance was going on. Meanwhile, as were not fruitful, in 1969, central government referred the disputes to Krishna Water Tribunal constituted. Justice Bachawat was selected as a chairman of the Krishna Water Dispute Tribunal. Other members were and Justice Shamsher Bahadur. These were the judges. So these three together form a tribunal. Part of this tribunal is that normally the tribunal in the technical matter is being assisted by appointment of assessors. In KWDT, this was not the case. There were no assessors assisting the tribunal. In fact, all the three riparian states have suggested that the tribunal can directly interact with the technical experts, engineers of the three-party states. And there is no need for assessors to assist the tribunal. This was accepted. And if one go through the finding of the Krishna Water Dispute Tribunal report, it will be seen that these judges have exerted extremely, had tremendous interaction with the engineers of the party states, with their councils, and in the award, most of the party states on most of the issues have finally given their understanding. Based on that understanding, the tribunal has given award. This is the beauty of the Krishna Water Dispute Tribunal 1. Why we call one is added now. because the tribunal, while giving the order, had suggested that by 31st May 2000, the things will be developed, there will be more systematic gauging, more advancements would be there, and therefore a review of their decision can be taken up after 31st May 2000. So with this background, now we will look into the tribunal's decision and what inputs were given before the tribunal. The entire Krishna River basin is an east flowing basin in the peninsular India, having catchment area of 259 lakh square kilometers. It is about 99,000 square miles. In the report, you will find most of the figures in square miles, acres, and that is the FPS system was adopted at that time. The proportion of the basin area, now the entire basin is lying in only 3 states. That is the state of Maharashtra, state of Mysore, now called as state of Karnataka, and state of Andhra Pradesh. The Bombay Presidency, the Madras Presidency, state of Hyderabad, and all that things have merged in these 3 states only. And the basin in Maharashtra is about 26.81%. That is 69,425 square kilometer, approximately about 28,000 square miles. Karnataka has the largest share of 1,13,271 square kilometers. That is about 40 to 43,000 square miles, which is 3.74%. And Andhra Pradesh has an area of 76,252 square kilometers. That is 29.45%. Letter of complaint states which were initially made in 1962 and 63 by Mysore and Maharashtra. They were followed by another letter from Mysore state on 8/7/1968, from Maharashtra state on 26th August 1968, and Andhra Pradesh. First letter on 21st April 1968, followed by another letter on 21st February 1969. Yes. Mr. Pandit has raised the question. There are no assessors in Krishna Godavari Tribunal 1, that is 1960 Tribunal of Bachawat. And emerging from the above letters on 10th April 1969, the matter to the tribunal for adjudication. So, made lot of complaints of all that thing. But the major claim which party states have submitted before the tribunal for adjudication is that Maharashtra needs about 828.70 TMC of water for their gross utilization. And in addition, Maharashtra requires 32.5 TMC from regeneration flow and to 80 TMC and domestic use. Demanded 1430 TMC gross utilization, but came up with domestic and industrial use. In the 1430 they demanded. Andhra Pradesh demanded 1888.10 TMC and also require 120 TMC additional water for water supply and industrial use. Considering the various complaints, party states and statement of cases, replies, counter replies, the matter was discussed by the tribunal at length with the councils and engineers, and they framed 7 main issues. The first issue is, was there any concluded agreement regarding allocation of water? This main issues had some 8. Those who are interested, they can go through the report to understand what are those 8 issues. But major was whether the agreement were concluding agreements or not. The issue was what direction equitable allocation is tribunal. For that also they have subdivided. There are sub-issues, 8 number sub-issues. Issue was regarding whether 1944 agreement, which was essentially for the Tungabhadra, is valid or otherwise. The fourth issue was again only that 1892 and 1933 agreements which were drawn long back, whether they are still subsisting or otherwise. This was the fourth issue. Should any direction be given by the tribunal by Maharashtra for benefit of Mysore and by Mysore for benefit of Andhra Pradesh? If waters are diverted in the Krishna basin, what should be given? And then what reliefs are to be given to the party and to which they are entitled. Now we are seeing the entire Krishna basin before you. Actually, the KG basin '61. There are several sub Krishna basin. And considering geographical area and all that thing, Krishna basin proposed that the entire Krishna basin be divided in 12 sub-basins. These are Upper Krishna, Middle Krishna and Lower Krishna on the main Krishna river, Upper Bhima on the Bhima sub-basin of the Krishna basin, Prabha sub-basin, Malaprabha basin, Vedavati sub-basin, then Musi, Pale. So this is how basins were identified for study purpose. Decision was taken is that below Krishna forms in delta portion and portion should water is there up to Krishna, up to Vijayawada Anicut, and whatever water is flowing over the Vijayawada Anicut, that should be considered for the purpose of determining what is the availability in Krishna water. Again, as I told you, these just were interacting with engineers, with the officers, and after discussion, common understanding by all the three parties were, and then agreed figures were being submitted. So the agreement between the three party states that water up to Vijayawada and overflowing Vijayawada could be harnessed and used. So here we were talking about the consumptive use for industrial. There.
Overall internet is
So this I am sure basis identified by its report, and the figures are in square miles. The last column gives you that is the general slope within the basin. Gives you how will be the rapid flow, the flatter, the slow velocity. Next slide, giving you of rainfall in one sub-basin has maximum rainfall Mune and so of surface where are the flows and where the flows are less. This gives the extent of districts which are the scarcity areas in the, as far as Maharashtra is concerned, Maharashtra has got Pune, Solapur, Ahmednagar, Usmanabad and Bid districts as the scarcity area. Mysore has got Bijapur, Bellary, Raichur, Huddar, Gulbarga, Chitradurg districts as the scarcity areas. Uttar Pradesh has got Mehboob-nagar, Nalgonda, Hyderabad, Kurnool and Anandpur districts. The division of population, cultural area, scarcity area and drainage contribution. These important factors arriving at the equitable distribution. So population wise, you will find that the largest population of 14.50 percentage wise it is population 30.7.4% was lying in Mysore district, Mysore state. 31.4% population was lying in Maharashtra and had 31.2%. Culturable area wise, 45.4% culturable area was from Mysore, 28.1% from Maharashtra and 26.4% was from Andhra Pradesh. The scarcity area, Maharashtra has got the largest scarcity area, 55%, and 13%. Maharashtra Mysore contributes 36.94% and Andhra Pradesh contributes 16.34%. Area contribution, that means water which is being contributed from that drainage area in the Krishna river basin system. The 1951 agreement, which was declared as void, that agreement at that time assessed that the dependable annual flow 1950 TMC and the utilizations are under construction. So that it was agreed that 176 TMC is Bombay. Mysore has very small trust, 290 TMC. About 700 and odd, and the balance flows which are available for allocations are 970.5 TMC, so approximately 100 TMC, which could be utilized by Bombay State, Hyderabad 280, Mysore 10, and 70 TMC. This was the picture in 1951 when there were major presidency and Bombay presidency, and Mysore was a very small part. These allocations assumed from only 67.5 TMC of water will be diverted. Subject to this proviso, the allocations were made and about 86% dependability. At that time, Maharashtra and Mysore, they were water dependability should be considered 75% as a safe basis for irrigation development. A question before this tribunal: what is the dependable flow and to what extent it is available? As I already told you that it was an agreement between the flows up to Vijay, the flows which can be utilized, and therefore there was an agreement between the three parties that flows of Vijayawada considered. In 1963, the Union Minister made a statement in the Parliament that incrementality of supplies for overall consideration, a criteria based on 75% dependability has been considered to be more suitable for our projects and may be adopted. So this is the basis why 75% dependable flows were selected. After discussion, the judges and the engineers of all the three party states and councils. The three directives, and accordingly they had their independent series from 1894-95, 1972, and the documents were filed before the tribunal. The availability of the flow. All these documents, three documents, is that 70% dependable figure of all the three series comes to 2060. So this is a notable thing, is that what extent the judges were interacting with engineers and how the figures were. So in general, there is an agreement that 2060 is the 75% dependable availability up to Vijayawada. Next. The issue is regarding distribution of the water. In 1966, there was a conference held international distribution of waters, and these conference have laid down certain rules. Each basin state is entitled, in international it is a country, with reasonable and equitable share in the beneficial uses of water of an international drainage basin. And equitable share within the meaning is to be determined in the light of all the relevant factors. That is, use is not entirely preference over any other use or category of use. A basic may not be denied the reasonable use of the waters of an international drainage basin to basin state a few of such waters. An existing reasonable use may continue in operation unless the factors justified are outweighed by other factors leading to the conclusion that it may be modified or terminated so as to accommodate competing incompatible use. The use that in fact is operational is deemed to have been an existing use from the time of initiation of construction, directly related to the use, or where such construction is not required, comparable acts of actual implementation. Such to be an existing use until such time as it is discontinued with the intention that it be abundant. And if use is compatible, it is treated as existing. Already we have seen that the demands. Demands which are exceeding 4,000 TMC are in excess of 75% flows ascertained by the with general agreement between the party states, that is 2060. So before the tribunal was, what is the existing use? Then there were discussions held among the party states and the members, agreed by all the three states that the use and the are under construction should get, and therefore the third column indicates the protected use. So Andhra had a protected use of 749 point, the largest 4.50 and 439.65 TMC. So almost 1600, between 1600 and 1700 TMC of water. So the balance water which was for sharing is 20 figure, which is about 300 and odd TMC. So this slide depicts you the from each basin which has been protected and had 186.41, that is 186. Mysore has very small 0.8. In K2, Mysore had major share 105.47, very small. In K3, Mysore had more share. K4, Maharashtra has larger share, and so forth. In K8, that is the was by Andhra Pradesh. That is because of their Krishna Delta, other canal system, Kurnul, Kadapa, and so on. Together, the uses were 439.6 in Maharashtra, 5.55 and 749.16. 1693.36 TMC use. It doesn't mean that at that time actual utilization was this much. We had seen the figures that it was only 700 and odd. Actions which were taken, committed use was there, and therefore it was a protected use. Next. So the water available is hard. They have extensively contested before the tribunal. All arguments, counter arguments were held. The Mysore were already by way of constructions. Andhra Pradesh has got major share, very small quantity of water is available, and therefore nothing should be given to and the balance water which is available for sharing should be distributed to the tribunal has given extensive, all those discussions are available in the KWV. And finally, the tribunal decided that we will give 120.35 TMC to Maharashtra, 90.45 TMC to Mysore, and 50.84 TMC to Andhra Pradesh. So total which is distributed is 560 TMC to Maharashtra, 700 TMC to Mysore, and 800 TMC. Total of 26 TMC of 75% dependable water assessed and agreed by the parties before Krishna Water Tribunal. The state of Maharashtra has made a case that the utilizations, there are certain flows which return back to the system, and therefore these regenerated flows, known as return flows, should be also taken into availability. There were a lot of arguments on this issue. Finally, three parties agreed that yes, there will be regeneration of the flow which will augment the flows, and various percentages were suggested from. Finally, it was agreed because they have considered up to 1971-72 for assessment of the flows. The existing till 1968-69 and the future on this contributing to the regeneration, because the regeneration from the flows already are utilized. They have been incorporated, considered already by the three parties. So with and which have been given and the individual states 68-69, the tribunal has arrested up to the figure that here till the parties TMC of water would be a regenerated flow from the utilizations that will be taken by the states from 1968. Now, major contributing factor will be from the irrigation. There are being utilized for water supply as well as industry. So here I agreed that as utilization is concerned, the use should be considered 20% of the similar 5% should be considered as the use. So no have been considered. The actual use is considered is only 20% and 2.5%. With the 25 TMC to Maharashtra, 34 TMC to Mysore, and 11 TMC to Andhra Pradesh, making total TMC, and final allocations were 55 TMC by Maharashtra, 734 TMC by Mysore, and 811 TMC. While these figures were being worked out by the tribunal, there were a lot of arguments and counter arguments about the sharing of the water. 75% dependability when we are considering. That means in 74% of the year's flows generated will be in excess of 75 TB. And those flows will be. So what is to be done? And extensively, tribunal has deliberated on these issues. And finally, because the contribution we have seen in earlier slides, that of the Andhra Pradesh is the least, about 16% and also. Till this is developed, still the utilization is developed. The tribunal ruled that the first flows available till development can be used by the Andhra Pradesh, and tribunal also have carryovers to this, so that their deficit in 25% can be from these carryovers. The various clauses of the order are now before us. Is that this will come into force after Gazette notification. States of Maharashtra, Karnataka will be free to make use of underground water. This is another thing which was also discussed in the tribunal. Water available is only 2060. Each state should use their underground works for the areas which are not covered. Clause 3 is 75% dependable flows available are 2060. Clause 4 is believe that clause 5 is the allocation by the tribunal. Then clause 5 is and clause 7, an important clause is that use shall be measured by the extent of depletion of waters of the rivers, whatever including losses of water by evaporation and other natural causes from the man-made reservoirs. That means if a reservoir of water is available, that is not the use. Whatever water has been actually used in the field, this is the definition of KWT 1. When measurement purpose, use measurement for and municipal water supply, only 20% is to be measured as a use. For industry, it is 2.5 and it is 100%. There are lot of arguments, heat arguments for use of outside the basin. As far as Maharashtra is concerned, Maharashtra, Tata Heddle and the water out of basin for hydration. As far as Andhra is concerned, historical uses were in Penna basin. So, when the economies have been developed based on this, such uses, this outside the basin use is legal. And another thing, that's no that this year I have used less, so I should get compensation. Nothing like that. Whatever you have used in that year, that is your use. Then they have stipulated certain restrictions. Because when you find that the contribution of individual state, particularly Andhra Pradesh, is 16% or so, whereas the utilization by way of use is much larger, and their streams should contribute enough water to the Andhra Pradesh state, and therefore they have made certain restrictions, applied certain restrictions. That in Ghataprabha, Maharashtra should use 7 TMC in K3 sub-basin. Then in Hima sub-basin, the main part of Hima, the utilization will not exceed more than 95 TMC, main Hima. Then whatever water has been allocated to, and there is another Maharashtra is that it will not divert more than 67.5 TMC for hydro generation through Koyna. And for as far as Tata is concerned, the restriction in 1 year it will be 54.5 TMC, but consecutive it will be 213 together. So approximately about 42.6 TMC on an average per year. That will be used by the Tatas and protected users because they were already undertaken. Tribunal. For Karnataka, whatever quantity has been specified, more than that will not be used by the Karnataka in Tungabhadra K8 sub-basin, and that was 295 TMC. Out allocated to the state of Andhra Pradesh, it will not use more than 127 TMC from Tungabhadra in K8 sub-basin, 12.5 from Vedavati, 6, not more than 6 TMC from Vedavati in Andhra Pradesh. And all these uses include losses. The Tungabhadra, they have further given directions that on the right bank low level canal, water use will be limited to 52 TMC. For Tungabhadra, right bank canal, Karnataka will use 22.5 TMC, Andhra Pradesh 29.5 TMC. Tungabhadra high level canal, 50 TMC water available in Tungabhadra. State of Karnataka will use 17.50 TMC and Andhra Pradesh 32.5 TMC. Tungabhadra left bank low level and high level canals will use 102 TMC. And assistance by way of discharges to Vijayanagar canals from Raya and Basavanna channels will be limited to 2 TMC. As far as Rajoli Banda is concerned, the use permitted is 7 TMC, Kurdul Kadappa 10 TMC, then they directed that working tables for the utilization of water in the Tungabhadra shall be prepared by Tungabhadra board or any other authority established in its place, so as to enable the states of Karnataka and Andhra Pradesh to utilize water available from Tungabhadra Dam. Next. As far as sharing is concerned, by an agreement between by an agreement between Karnataka and Andhra Pradesh, they can modify their sharings. Clause 10 restricts Maharashtra from more than 67.5 TMC in Koyna diversion. For Tata, as already I told you, that in 5 years together 213 TMC. Then by clause 11, the tribunal has directed that all the previous agreements, that is 1892 agreement, 1933 agreement, 1944 agreement, 1945 agreement, 1946 agreements, all these stand superseded by these orders. The tribunal has suggested by order 12 gauging sites and systematic gauging of the Krishna River. They have also directed that each state shall prepare and maintain annually for water year complete, detailed and accurate records of annual water diversions outside Krishna River basin, annual uses for irrigation using less than 1 TMC, and annual uses for irrigation, all other projects and works, annual uses for domestic and municipal water supply, annual uses for industrial purpose, annual uses for irrigation within the Krishna River basin from projects using 3 TMC or more, areas irrigated and duties adopted for irrigation from irrigation works using less than 1 TMC annually, estimated annual evaporation losses from reservoirs and storages. Then another important provision is that send to the other states summary of abstract of the records and records are open for inspection by either parties. Then clause 40 that the decision of the tribunal can be reviewed after 31st May 2000. There is another provision, important provision in clause 15 that by agreement between states, they can modify. And water year has been indicated to be from 1st June and ending on 31st May. And then other things are regarding the bearing the expenses of the tribunal and all that. So this is in nutshell the directives of the Krishna Water Dispute Tribunal 1 and how the tribunal exercised the parties for an agreement on various issues which were created at that time. How that is the beauty of this tribunal's award of Krishna Water Tribunal. Thank you, Mr. All the participants.